Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 2 of our new series entitled The Slippery Slope of Substantial Medical Evidence. And I want you to know I'm very excited about this program. Probably more excited than I've been for any of our more recent programs. And the reason is, it's my opinion that this program has the greatest potential to improve your skills and your value as a qualified medical evaluator. That's number one. And then number two, this program, if adopted by 10, 20, 30, 100, 1,000 qualified medical evaluators, has the potential to dramatically change the profession as we know it, and has the potential to dramatically improve the system as we know it. And let me just elaborate on that a little bit before we get into today's discussion. I was recently at some meetings down at the Division of Workers' Compensation, and there were many other participants at the meeting. Some of the participants at the meeting included claims administrators, claims payers, in other words, executives and senior claims adjusters for major insurance companies throughout the state of California. And the general frustration of the claims payers had to do with the work product that we as qualified medical evaluators plop on their desk. And they lamented that the work product that we produce as qualified medical evaluators was shabby in that the opinions and conclusions that are offered by qualified medical evaluators across the board are not opinions and conclusions that can be used the first time around. And so claims payers throughout the state, both large and small insurance companies, lament that they have to go back time and time and time again to the qualified medical evaluator to finally get opinions and conclusions that approach substantial medical evidence and that approach usability for the resolution of disputed issues. And this has two unfortunate and unforeseen consequences. And that is, number one, that it dramatically escalates the medical legal costs associated with the claim. And that's a big deal for claims payers because they have to set aside certain reserves in order to cover these expenses, and they don't like curveballs, and they don't like variability, and they don't like surprises. So that's one thing, is that the costs rise dramatically. The second thing is that it introduces incredible delays in the resolution of disputed issues, as claims payers have to go back to the qualified medical evaluator for a supplemental report, which could add an additional 30 days, 60 days, 90 days, just in order to obtain an answer to a question that they already posed to the qualified medical evaluator in the initial evaluation. And they have to go back for supplemental report, and they have to go back and depose the doctor, and they have to go back and ask for a reevaluation as the doctor attempts to shore up what he should have done, what he or she should have done in the first initial evaluation. So the costs are tremendous and the delays are even greater, and this is a problem for the claims payers. So if we as qualified medical evaluators can improve our work product, improve the quality and content of our opinions and conclusions, if we can elevate our opinions and conclusions to a standard which can be used by the parties in the resolution of disputed issues, the system itself as a whole will run much more smoothly, much more efficiently, and cases can continue to be resolved instead of continue to be clogged in the system. So this program, Substantial Medical Evidence, has tremendous potential to improve your career as a qualified medical evaluator and your reputation as a qualified medical evaluator, and on a much larger scale has the potential to dramatically improve the efficiency of the entire system as we know it. So I hope you pay particular attention to the ideas and the concepts that I'm sharing with you in this program. Now, before we begin today's discussion, and I have a fascinating discussion for you today, let's just review the philosophy of this program. Philosophy of this program has to do with defining what substantial medical evidence is and how to qualify your opinions as substantial medical evidence according to the criteria that have been established in case law over the decades. And in fact, I shared with you one case, the Zemke case. Zemke case goes back almost over 50 years ago. So that's a half a century of history in the defining of substantial medical evidence. So I shared with you several cases, the Zemke case, the Garza, West, Granado, and the Escobedo cases. And we will review a couple excerpts from those cases as relates to our purposes and our definition of substantial medical evidence today. So we'll review some of those. And then we talked about how once you get through the mechanical introductory phases of learning how to provide opinions and conclusions that qualify as substantial medical evidence, after you get through the mechanical, heavy thought-making process, how that process is going to become more and more automatic for you. And in the beginning, establishing your opinions and conclusions as substantial medical evidence is going to be a method of writing your opinions. But over time, as you become more and more comfortable and more familiar with the idea of qualifying each and every opinion and conclusion that you offer as substantial medical evidence, it's going to become a way of thinking and even a way of life for you outside of your medical legal practice, if you can believe that. And I shared a couple of illustrations of just that in our last session. So as you become comfortable with substantial medical evidence, you're going to come to rely on the opinions and conclusions that you offer in your report. And you're going to come to be comfortable with the opinions and conclusions that you offer in your report, knowing that those opinions and conclusions are substantial, meaning they've been escalated and elevated to a high standard. They've reached the lofty ideal of the holy grail of opinions and conclusions, and that is the high ground wherein live opinions that are substantial opinions, substantial medical evidence opinions. And I want to give you just an example as to how comfortable you can become in relying on the opinions and conclusions that you offer when those opinions and conclusions qualify as substantial medical evidence. A personal example. This isn't the first time this has happened, but it's in my recent memory because just yesterday I had a deposition, and one of the attorneys was asking me several questions, all of which were previously discussed in my 2 reports. And as the attorney asked me these questions, I found myself defaulting to one basic answer to her questions, and that was, well, I answered that question in my report. My answer to that question is on page 32 of my report, and I thoroughly discussed that issue, and you'll notice that I qualified each and every one of my opinions as substantial medical evidence. So what additional question do you have? And the attorney would rephrase the question and come at it from a different angle, and I would simply default to the answer. I addressed that in my report, and you'll notice that I qualified my opinions as substantial medical evidence. And when you can qualify your opinions as substantial medical evidence, they're correct, they're accurate, they're the truthful answer, they're the truthful resolution, they're the accurate resolution, they're the perfect resolution to the disputed issue in the case. Because the process of defining your opinions and qualifying your opinions as substantial medical evidence is basically a truth serum formula for your opinion. Substantial medical evidence puts truth serum on your opinion. And if your opinion can survive the truth serum, it's because it's true. So once you become comfortable with substantial medical evidence, you can sleep well and you can rely on those opinions and conclusions, knowing basically that your opinions and conclusions will be irrefutable. We also talked about how to integrate, and we're going to further elaborate on this, how to integrate your opinions and conclusions into the body of your report, such that every opinion and conclusion that you offer in your report is as solid as a rock and is accurate for the circumstances of the case. Once you've done that, you can relax, knowing you've always made the correct decision. And you're going to find that substantial medical evidence, qualifying your opinions as substantial medical evidence, is a medical decision-making algorithm. It's a formula. It's a process that has been elucidated over the decades to help us in our medical decision-making, such that the decisions that we offer are always accurate. It's a system and it's a formula that you can rely on and you can relax with, knowing that you're protected because your opinions are substantial, okay? And then finally, in improving and constantly improving the opinions and conclusions that you offer in your report, we're going over several case law examples where, number one, qualified medical evaluators were successful in having their opinions and conclusions upheld because those opinions and conclusions qualified as substantial medical evidence. So we're sharing examples as to how QMEs were successful. And then we're also sharing some examples as to how QMEs and even primary treating physicians failed to have their opinions and conclusions upheld because those opinions and conclusions failed to qualify, or I should say the QME failed to qualify the opinion or conclusion as substantial medical evidence. And I have one such case to exemplify that failure in today's discussion. Okay, so in today's discussion, I want to continue to elaborate on the definition of substantial medical evidence and show you some practical examples as to how you can compose and comport your arguments within the body of your report, such that your opinions and conclusions can clearly stand out to the reader of the report as substantial opinions and conclusions. And then I have a very fascinating case to share with you where both the primary treating physician and the qualified medical evaluator failed in their attempts to qualify their opinions as substantial medical evidence. And there's several illustrative principles to share with you regarding that case. So with that as our introduction, let's begin today's discussion in session 2 of our new program entitled The Slippery Slope of Substantial Medical Evidence. Okay, so to begin, let's just review some of the teaching points from the important case law examples that we reviewed in our last session. And in our last session, we went over in more detail the Garza, Zemke, West, Granado, and Escobedo cases. So for today's program, let's just review and refresh our memory as to the important principles espoused by each of these cases. So the Garza case tells us, and this is instructive for us, that any award, any order, and even any decision, imagine that, any decision of the board must be supported by substantial evidence in light of the entire record. Okay, so this is a principle of case law that has become operative in every single case that's heard by workers' compensation judges and that's heard by the appeals board. Any decision that they offer must be supported by substantial evidence in light of the entire record. So the workers' compensation judges, the board, cannot use opinions if those opinions do not qualify as substantial medical evidence. They can't use them. So down at the board and the workers' compensation judges, when they're faced with a difficult decision, they look to the evidence. And the first thing they look at the evidence is whether or not the evidence qualifies as substantial. they don't first read the opinion. They don't first digest the philosophy of the opinion. They first look at the form and the substance and the outline of the opinion to determine if the opinion contains within it the criteria that would qualify that opinion as substantial medical evidence. If the opinion does not contain the criteria, the opinion is thus discarded and cannot be used, because the board cannot base a decision, cannot base an order, cannot base an award on evidence that does not qualify as a certain standard, and the standard is substantial evidence standard. Okay? Then Zemke and these other cases start to inform us as to how we as qualified medical evaluators must fashion our opinions and conclusions in order to contort them and twist them and mold them and shape them into opinions that can be used down at the board. Okay? And Zemke told us that an opinion that does not disclose its underlying basis and gives a bare legal conclusion does not constitute substantial medical evidence. So the cue and the clue from the Zemke case is for us as qualified medical evaluators to share with the parties the underlying basis of our conclusions. Share the basis for our underlying conclusions. Explain to the parties why, and how and why we came up with the conclusion that we came up with. Show the parties the cards upon which the opinion and conclusion is based. The West case informed us that an expert opinion, which is our opinion, qualified medical evaluators are medical experts, we're considered to be experts, the expert opinion is no stronger than the facts upon which it is based. So the West case gives us another clue, and that is that our underlying basis that we're going to share with the parties should be based upon facts, So you must have facts to support your opinion and conclusion. Where are those facts going to come from? Where would you think you would discover the facts upon which your opinions and conclusions would be based? Well, you're going to discover those facts in your interview with the examinee. You're going to discover facts in the review of records that you do. You're going to discover facts in the physical examination. You're going to discover facts by reviewing diagnostic studies. All of these procedures and all of these portions of the evaluation serve as sources of the facts upon which your opinions and conclusions will be based. So the parties are asking us to share our facts. Please share our facts. The Granado case informed us that a mere legal conclusion does not form a basis for a finding. In order to qualify as a substantial finding, the bare legal conclusion must be based on facts, and it must disclose its underlying basis. Okay, and then finally, the Escobedo case, and the Escobedo case is extremely important for us because the Escobedo case is a case that was currently resolved through an en banc decision. En banc means that it's binding now throughout the state of California on all judges, on all appeals board. It's a binding decision on all parties. This case came down in the new era since 2005. It was the 2005 Permanent Disability Rating Schedule, and the apportionment laws passed as a result of Senate Bill 899. In other words, apportionment laws, Labor Code 4663 and 4664 are operative in the Escobedo case. So this is a contemporary case that was resolved within the current era in which we're currently practicing as qualified medical evaluators. So it's a very relevant case. So Escobedo tells us that medical opinion must be predicated on reasonable medical probability. A medical opinion is not substantial evidence if it's based on facts no longer germane. if it's based on an inadequate medical history or an inadequate medical examination, and if it's based in any way on guess, surmise, conjecture, or speculation, and it must provide the reasons behind the physician's opinion, not merely his or her conclusions. So very interesting. I remember some years ago, approximately 10 years ago, I had a series of depositions with this one particular law firm in the Central Valley. This was an applicant attorney law firm. And I remember that after asking me many questions, the applicant attorney went through a process to establish my opinions as substantial medical evidence. In other words, he took it upon himself to establish my opinions, which were obviously applicant-oriented and favored his client. He took it upon himself to establish those opinions as substantial medical evidence, and he did something that at the time I considered to be very clever. So after he confirmed all of my opinions and conclusions, he would ask me, Doctor, is your opinion based on reasonable medical probability? And I would say, yes. And he would say, Doctor, did you take a history of Mrs. Jones? And the answer would be yes. And Doctor, did you perform a physical examination of Mrs. Jones in accordance with the AMA guides? And the answer was yes. And he would say, Doctor, is there any aspect of your opinion or conclusion that's based on speculation, conjecture, or surmise, or guess? And the answer was no, of course. And he went through this process to qualify those opinions and to confirm those opinions as substantial medical evidence, because once that process was complete and the opinions were confirmed as substantial opinions, the opinions basically were upheld because they were irrefutable, because they were based on facts, because they provided the underlying basis of the opinion, because they were based on an adequate exam and an adequate history. So these cases are illustrative, and I want to share with you an example as to how you can apply these principles in your very next evaluation. So in your very next evaluation and in your final product, your QME report, where is substantial medical evidence required? Which sections of your report lend themselves to the requirement of substantial medical evidence? Well, basically, the answer to that is that anytime you offer an opinion or conclusion, which has a subjective element to it, correct? Okay, this opinions and conclusions are different than you citing facts. Okay, a fact might be Mrs. Smith's lumbar spine range of motion. When you say in your report Mrs. Smith's lumbar spine range of motion was 60 degrees, that's not an opinion or conclusion. That's a statement of fact. Okay, those don't require qualification. It's where you offer opinions and where you offer summaries and where you offer conclusions is where you need to qualify those opinions, summaries, and conclusions as substantial medical evidence. Now, that could apply to your range of motion findings. In other words, if you at one point in your report cite the range of motion findings as facts, but then you offer us an interpretation of what those range of motion findings mean to you, that interpretation should be qualified and must be qualified as substantial medical evidence. So basically, anywhere you offer an opinion or conclusion in your report, such as in your assessment of the examinee's limitations with activities of daily living, that's an example where you should qualify your opinion and conclusion and your summary as substantial. As I said, your physical examination findings, many times in our physical examination, we provide the finding. Okay, we provide the finding, but then we must provide the interpretation of the finding. We must provide the analysis of the finding. We must explain to the reader of the report what that finding means in terms of the examinee's condition and in terms of the examinee's qualification for workers' compensation benefits. And it's this analysis, it's this interpretation, it's this explanation that we need to qualify as substantial medical evidence. So in this case, the opinion and conclusion on our interpretation of the physical examination findings is based, according to Escobedo, on facts, and in this case the facts are the range of motion findings, or our observations on range of motion testing. So the physical examination is an area where you may provide opinions and conclusions, and if you do, they should qualify as substantial medical evidence. Certainly in the causation section of your report, especially nowadays with the glut of cases that are denied cases, wherein the whole disputed issue, the whole issue in dispute with the evaluation is compensability under Labor Code 4060. AOE COE is the disputed issue. So when you opine on AOE COE and the presence or absence of an industrial injury, that opinion must, it absolutely has to qualify as substantial medical evidence. Otherwise, the parties are left in a lurch. Okay, the parties are left in a lurch, and that's a terrible disservice to all the parties. So your opinion on causation must solve the issue. And the only way it can solve the compensability dispute is if the opinion or conclusion qualifies as a substantial opinion and conclusion. On permanent impairment, your opinions and conclusions should qualify as substantial medical evidence. And if you provide for alternative impairment ratings under Alvarez and Guzman, the opinion has its own set of criteria that it must meet in order for that opinion and conclusion to qualify as substantial medical evidence. So providing for alternative impairment ratings under Alvarez and Guzman is slightly different, but it follows the same type of a concept in that you must explain to the parties how and why your permanent impairment, your alternative permanent impairment rating is more accurate than the permanent impairment rating provided for by the strict application of the AMA guides. And then finally, of course, regarding your apportionment determination, your opinion on the apportionment approximate percentages must be based on substantial medical evidence. And this is especially tricky because anytime you provide an apportionment determination, you provide two conclusions. Number one, you provide a conclusion for the approximate percentage of the permanent impairment that's due to the industrial injury. That's one conclusion. And then the other conclusion is the percentage of permanent impairment due to other factors. So when you say in the body of your report, in my opinion, within reasonable medical probability, 70% of the permanent impairment is due to the industrial injury, and 30% of the permanent impairment is due to other factors, you then need to qualify the 70%, and you then need to qualify the 30% and explain how and why with facts and the underlying basis as to why 70 versus 65 versus 75, why 70 is due to the industrial injury. And then you need to go through the same process and explain why 30% as opposed to, say, 25%, or say as opposed to 35% is due to other factors. So with apportionment, it's especially challenging, but it can be done, and I'm going to share with you in our very next program how to establish your apportionment approximate percentages and how to qualify them as substantial medical evidence. For today's discussion, I want to share with you some ideas as to how to qualify your opinions and conclusions on causation. In other words, the AOE COE compensability determination, how to qualify those opinions either for industrial injury or against industrial injury as substantial. And I want to share with you that the process of qualifying your opinions and conclusions as substantial medical evidence is a medical decision-making algorithm. It's an algorithm that you can use to arrive at the true and accurate determination as to whether or not your examinee actually suffered an industrial injury or did not suffer an industrial injury. And this is going to be fascinating for you because this algorithm will lead you to the correct and accurate conclusion every single time. Every single time. So let's talk about substantial medical evidence and your causation determination. Now, your causation discussion is going to be found in the discussion section of your report. And the discussion section of your report is going to make up approximately the remaining 50% of your report. The first 50% of your report is wherein you elaborate on the history, wherein you do an activities of daily living assessment, wherein you do your physical examination, wherein you discuss the findings of diagnostic studies, and wherein you establish all of the facts of the case. Okay? So once all of the facts of the case are established, you can then go in your discussion section where you answer the questions that are associated with the issues in dispute with your particular evaluation. And the discussion section of our report and our requirements as qualified medical evaluators for addressing issues in our report is described in CCR 35. And CCR 35 informs us that the evaluator, which is us, shall address all contested medical issues arising from all injuries reported on one or more claim forms prior to the date of the employee's appointment with the medical evaluator that are issues within the evaluator's practice and areas of clinical competence. And herein is our directive. It tells us that the reporting evaluator shall attempt to address each question raised by each party in the issue cover letter sent to the evaluator. Now, many qualified medical evaluators do not do this. They do not painstakingly and deliberately answer the questions that are asked by the parties in the cover letters. And this is where you and I have tremendous opportunity to benefit and improve the system as a whole by once and for all in our reports giving the parties the answers to the questions for which they hired us to answer. What a concept. Isn't that such a funny concept that we should have to deliberate over this? But that is one of the complaints of the parties, is that they send us these cover letters, and yet the reports that they get from us do not address the questions from the cover letters. So what I'm asking you to do from here forward with your evaluations is in your report, in the discussion section of your report, you write out each question posed to you by the parties. Now, this could be many, many questions when you have two cover letters, one from an applicant attorney, one from a defense attorney. This could be 20 to 30 questions. Well, you write out each question in the body of your report, and then you answer those questions in the way that the question was addressed to you by the parties. So let me give you an example. Imagine you have a 12-year-old son, and you give your 12-year-old son the job of vacuuming the interior of your automobile. You tell your son that you want him to vacuum the front passenger compartment and the rear passenger compartments, including the upholstery and including the carpeting where people trample their feet, okay? And you give him very specific instructions. Well, an hour later, he comes back to you and you ask him, son, did you vacuum the carpet on the passenger right front? And he says to you, car's all clean, Dad. And you rephrase your question and you say, did you vacuum the floors as I asked you? And he says to you, I checked the tire pressure, Dad. and he's answering questions of what he's done, just like we as qualified medical evaluators, we do certain things in our evaluations and we address issues that we feel are issues that need to be addressed, and we don't specifically answer the questions that are posed to us by the parties, and we don't answer those questions in the language with which the question is asked of us. And that's what I'm asking you to do from here moving forward, and we're going to talk about just how to do that with your causation argument. So let's talk about providing substantial opinions on the AOE COE determination in your report and how to answer the difficult disputed issue of compensability under Labor Code 4060. So imagine this. So imagine that your very next evaluation is a claim wherein the disputed issue has to do with compensability under Labor Code 4060. Let's just, for sake of example, let's just imagine that this is a case that involves a denied claim for an examinee who has filed a claim post-employment for a cumulative trauma injury. Okay, so this is a post-employment cumulative trauma injury claim which naturally has been denied by the claims administrator. And this case comes to you under Labor Code 4060 for your expert determination for an opinion as to whether or not this examinee qualifies for workers' compensation benefits. So the determination that we require from you is either a thumbs up opinion for FOR industrial injury or a thumbs down opinion against industrial injury. And you'll know and you'll agree, if you've ever had these types of cases, that these types of cases are very, very difficult. Many of these cases involve an unwitnessed incident with a delay in reporting or no reporting at all. In fact, for post-employment claims, there's many times there's no report ever during the employee's relationship with the employer. There's no report ever of any symptoms or any injury or any need for medical care. And so for us as qualified medical evaluators, these are very, very difficult determinations. And importantly, the determination has to be correct every single time. It has to be correct. The consequences are very serious on these cases. So how do you decide? How do you make a decision either for or against industrial injury? And how do you qualify your decision or your opinion as a substantial opinion that will be upheld and that will be used to resolve the disputed issue? Well, as I said earlier, the process involved in qualifying your opinions as substantial medical evidence is a medical decision-making system. And here's where the system comes into brilliant operation with regards to your causation determination. What you do is you take a piece of paper and you draw a line down the center of the piece of your paper right here. And in the left-hand column, you create your argument or your opinion for industrial injury. And in the right-hand column, you create and formulate your opinion against industrial injury. Now, as you know, in many of these cases, the opinion can go either way. In other words, we weren't there at the time. We don't know if the examinee suffered an industrial injury, correct? This is the way many of these denied cases are. Many denied cases involved an unwitnessed incident with a delay in reporting, and we as the qualified medical evaluator, because we weren't there, have no way of knowing whether the examinee actually suffered an industrial injury or whether the examinee did not suffer an industrial injury. So here is how you decide, and here is how you discover the accurate determination. So you formulate your argument for industrial injury on the left side, and you begin that argument in typical fashion by telling us, in my opinion, within reasonable medical probability, the symptoms that Mr. Jones reports in his lower back are the result of an industrial injury on January 1st, 2020. Reasons for this conclusion include, and then you provide a listing of reasons. Reason number 1, reason number 2, reason number 3, 4, 5, bullet points, reasons, citing facts, citing the underlying basis, providing the facts from the history, facts from the examination, making sure that all of your reasons contain no evidence of speculation, no guess, no surmise, no conjecture, and you write out your argument. On the other side of the page, you write out your argument against industrial injury, beginning in typical fashion, and you say, in my opinion, within reasonable medical probability, the symptoms that Mr. Jones reports in his lower back are not the result of any industrial injury of January 1st, 2020. Reasons for this conclusion include, and here again, you provide your reasons, your multiple, voluminous, and compelling reasons with support from facts from the history, facts from the examination. You review all of your arguments and make sure that there's no speculation, no surmise, no conjecture. And then you look at your lists. And guess what you're going to discover? What you're going to discover is that your list is probably skewed. One argument compared to the other argument is going to appear to be more compelling. It's going to appear to be more supportable. It's going to appear to be more based on facts. It's going to appear to be more substantial than the other. And as an example, when you write out your opinion for industrial causation and you're able to list 6, 7, 8, 9, 10 bullet points of support for an opinion for industrial injury, whereas your opinion against industrial injury only has 3 supportive facts, 3 reasons, 3 citations that you can use to bolster that opinion, well, the lists are skewed. The reason that the lists are skewed is because one of these opinions has the greater likelihood of being the true opinion. It has the greater likelihood of being the accurate opinion, and that opinion is the opinion that can be qualified as substantial medical evidence with multiple and compelling and voluminous reasons. And the other has few reasons, has little support, has little underlying basis for the opinion. It has little substance. So when you have arguments like this and you look at the arguments, you simply choose the argument unemotionally. You unemotionally choose the argument that has the greater support. On the other hand, if your argument looks like this and the argument for industrial injury has very little support, maybe only 1 or 2 bullet points or 1 or 2 things that you can point to, 1 or 2 facts, 1 or 2 references in the medical records. In other words, it has very little support. Whereas your opinion against industrial injury has multiple and compelling facts and multiple and compelling bases upon which your opinion is supported, well, you simply look at the 2 lists and unemotionally you go with the opinion that has the most support. It's not that we arrive at an opinion in our head and we try then to create support for that opinion. That's not how we make medical decisions in the qualified medical evaluation. We make medical decisions based upon which decision has the most support, which decision can be supported with substantial medical evidence. So let me ask you a question. If you had this type of scenario and you went through this exercise and you were charged with making a determination on compensability under Labor Code 4060, and you did this exercise and you made your listing and you came up with your argument for industrial injury and you came up with your argument against industrial injury, and you violated this table, and the opinion that you provided in your report was an opinion for industrial injury, when knowing in your heart that that opinion has very little basis and very little support, and all the while also knowing that the opinion against industrial injury has multiple voluminous and compelling support, but you chose to offer this opinion here for whatever reason, for whatever motive or motivation you may have, but you chose to offer this opinion here. Let me just ask you, how would you feel in deposition when questions regarding your causation determination start to be posed to you rapid fire by the bulldog parties deposing you? How are you going to feel? You're not going to feel comfortable. You're not going to feel what I described in the introductory section of today's video. You're not going to feel relaxed. You're not going to be very relaxed, knowing that the opinion and conclusion that you offered really does not have any support, that you simply provided that opinion or conclusion because you were emotional about the case, or that you were had a motive, had an external incentive or some other motive to provide that opinion and conclusion. And our goal is to improve the accuracy of the work that we do by providing opinions and conclusions that are substantial opinions and conclusions. So when you write out your lists here and you write out your arguments both for industrial causation and against industrial causation, you look at the argument and you look at which argument is the substantial argument, and that's the argument that you go with. And that's the argument that has the greatest likelihood of being the true argument. It's the argument that is the more accurate determination because it has support. It has basis. It's based on facts. And that's how you do your medical decision making in the medical legal type of work that we do. Okay? And this also goes for your permanent impairment determination. It goes for your apportionment approximate percentages. You simply create a list. You know, this list, if we were talking about apportionment, here at the top of this list, it might simply say 70% industrial and 30% other factors over here. And then you would write out your argument as to why 70% is accurate, why 30% is accurate. And then you would do the same thing for 80-20. You would create another argument. And then you would create an argument for 90-10 and an argument for 50-50. And you get the idea, right? And you look at those arguments, and the argument that has the most support, that is the most substantial argument, is the argument that you'll go with. It's the argument that you'll use in your reporting because it's the argument that you can relax with, knowing that it's a substantial argument. Okay? So doctors, I hope this helps you. These are principles that are going to be available to you in every single opinion and conclusion that you offer throughout the remainder of your career. And you're going to find that once you start thinking in this way and thinking in terms of supporting your opinions and conclusions, you're going to find that it spills out over into your daily life and in your interactions with the people close to you in your life. And no longer are you going to simply accept opinions and conclusions from the people in your life. You're going to be asking those people in your life to support their opinions and conclusions and to explain to you how and why they came up with their opinions and conclusions. And as a qualified medical evaluator, we can ask no more of you. So for today's session, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me. I look forward to being with you in our very next session as well, as we continue our ongoing series entitled The Slippery Slope of Substantial Medical Evidence. For now, I'm wishing you the best success in your career as a qualified medical evaluator.